Welcome to the next episode of our podcast on negotiation. And our today's guest, Michael Mcilwrath, is an expert in dispute resolution, someone who has spent his entire career as a litigation lawyer, someone who has been very successful in the domain, both professionally as well as academically. Maybe I should reverse the sequence. You were first an academic and then became a professional, and someone who will tell us how to negotiate international commercial contracts. Michael, it's great to have you with us.
Thank you. It's great to be here. Thank you for having me.
Michael, how did your whole adventure with negotiation and dispute resolution started? Your educational background is in litigation, right? You're
Yes.
an educated lawyer. How did you make the switch to negotiation?
Well, yeah, out of necessity. And by the way, I thank you for inviting me on. And I just want to make sure that I mention before I forget that I've had a chance to listen to many of your previous podcasts. And I reckon for anybody who knows me, I would recommend them to others to go back and listen. There are some fabulous tips that people can pick up and just approaches to negotiating. So I came to negotiation not formally, but through a need as being an in-house lawyer who had lots of disputes, lots of problems to resolve, a very high workload. And actually, I prepared some charts. I can kind of walk you through them. I know the people who are just listening, they won't be able to see them, but you're not really missing out on that much. So if I'll pull those up. My career internally, I was a lawyer practicing in New York. I spoke Italian. I'd lived in Italy earlier after graduating from university and before becoming a lawyer. I worked in New York initially in my first part of my legal career for a New York law firm for a number of years. And in 1999, I got hired by General Electric, which had recently acquired a global company called Nuovo Pignone. Nuovo Pignone was, until 1994, it was owned by and controlled by the Italian government. It didn't have its own independent legal department, and so GE went about hiring lawyers to put them in place. And I was one of the first people that was hired as part of that team. And you can see, I understood really quickly why they hired a litigation lawyer as one of the first members of the team, is they had lots of disputes. It was, by the time I got around to counting them, which is maybe 3 or 4 months after I started there, I was just so busy. About 143 globally, all over the world. Some were in the courts, some were in arbitration, but these are cases that were actually filed. They were pending somewhere, and it was a substantial workload. I was by myself as an in-house counsel, and I remember the general counsel of GE asking me at one point, "How do you manage so many of those cases all at once?" And I think I was honest. I said, I can't. How do you? It's too many. And I was able to find within General Electric a document that pointed me to a program that GE had implemented with success a few years earlier called early dispute resolution. And early dispute resolution had this focus, as it said, what GE called informal methods of resolving disputes. And it said clearly negotiation and mediation. And I knew nothing really about either. I mean, I thought, like most people, I used to say in these courses I would teach, that we have many people who are great negotiators here in the company. We have many people who think they are great negotiators, right? Everybody thinks they're a great negotiator. But I really had no background or training in either of those. But I went about implementing this program to attack these 143 disputes that we had. And keep in mind that the company was very active, it was growing. So it's not like you would close one case and that's it. It would be, you close one case and 2 more would come up knocking on your door. As GE is now selling all over the world, it's really expanding this business. And so I was very busy. And yet, by having this emphasis on early resolution, and we didn't do many mediations, but we did a lot of negotiating. And we were able to reduce the caseload in just a couple of years from 143 pending cases to about 25. And by the way, I heard Professor Mike Wheeler once speak at a conference, and he was talking about how for a large company, what is the right number of disputes, litigations, and the answer is it's not zero, because zero would mean that you're leaving nothing on the right. You're leaving a lot on the table and you're settling everything. And in my case, I would have said 143 was far too many, and zero would have been far too few. 25, I think, wound up to be about the right number for the size of the company where we were. And we reduced our spend on external everything relating to litigation, not just law firms, but arbitrators, court filing fees, and everything else associated with disputes by 50%. So the program actually worked really well. And Professor Wheeler at the Harvard Business School actually, a couple of years later, had an opportunity to work with him, because he did didn't work with him. We collaborated on a case study that he did about the implementation of this early dispute resolution program within General Electric. So that was how I think I got thrown. It was, let's say, a baptism by fire, not really knowing well what I was doing, but having to learn as I went, which then led me to thinking about, well, I really ought to be acquiring skills here, not just for myself, but for others in the company as well. And this led, and in particular, where I really needed to be applying the efforts was in making sure that the disputes didn't become pending cases, right? To finding ways to prevent them, to avoid them, but in a good way, so the company would get good results, but didn't have to expend unnecessary resources in court or in arbitration.
Right.
And so that's what I think led me to, how can we develop mediation and make it part of the DNA of the company. And the initial work that I did there, and I was fortunate at that time, there was this organization in Italy called the ADR Center, which was founded by two people I think you may know, Giuseppe De Paolo and Leonardo D'Urso, who were fresh out with their new business, trying to propose mediation way before anybody in Italy had heard of what mediation was. I had just discovered mediation, and we connected, and they said, well, we do know a lot about negotiation. They came in and I began helping us develop our first negotiation trainings, and I was able to identify, it wasn't very difficult to see, where are the touch points, where are these disputes being created. And for a company, this company, GE Oil and Gas, which became GE Oil and Gas Novo Pignone, these were major energy projects. They were energy plants. They were liquid natural gas installations. But these were big financially intensive refineries, capital intensive and technology intensive projects. And the people who were, I would say, manipulated the levers that would lead to disputes or avoid disputes were project managers, PMs, you would call them project managers. And it became clear that if we could influence or provide them with the skills to negotiate better, that perhaps they would themselves would be able to resolve disputes successfully, so that it wouldn't come to me. And so really this was all about making my job easier. So I did a lot of work. We brought in the ADR Center with Leonardo and Giuseppe, who did some fabulous work helping to train people. We brought in Professor Richard Schell from the Wharton School of Business. We also brought in Professor Michael Wheeler from the Harvard Business School. I mean, we really invested in bringing in some great talent to help us to teach this community that we had. And of course, my community of the project managers was what I was targeting. But of course, then the sales people would hear, so I hear there's a great negotiation course being taught for the project managers. And they would always try to sneak into our courses, and we didn't kick them out. It was something that was really requested once we began to do this within the company. And then eventually, but not long after this, it essentially became institutionalized across the company. We latched on to an initiative that GE had created within this business called the Project Management Academy, PM Academy, which had a series of trainings that were required for all project managers. Some of this was engineering, some of it was related to anti-corruption, things that project managers need to be aware of if you're working in difficult places around the world. Some of it related to financial matters. The project managers are like often mini CEOs. They kind of run their own business. And there was a negotiation training path that was part of it. And when we trained thousands of project managers over the years on in various forms of negotiation skills. And we broke that out into 3 different levels of negotiation training that the project managers were required to go through. One was level 1, which is what we called it negotiation fundamentals. That was our level 1 course. It was a full day. We ideally, and the criticism and the feedback we always got was that people wanted it to be 2 days, not 1 day. But in a big company, it's hard to get people together to do. A lot of people fly in for these courses. This is pre-pandemic, pre-world of virtual, and getting 20, 30 people into a room, right. You're taking away a lot of their time from the business. And so, but it was nice to get criticism that everybody would say that this class needs to be 2 or 3 days. And so we've got to keep it to 1. And that I think was almost like a core competency of the project managers, a core skill that they would apply. And the idea, we even had project managers who would come in that would come back and teach the course. Again, trying to make this as part of the DNA of the project management organization. We then had a level 2, and this is where I think things got really interesting and really beneficial to the company. But level 2 trainings are what we never thought of a good word for them. We call them legal negotiation, but that wasn't really what it was. We just didn't, not very creative with respect to titles. But the level 2 trainings were targeted on those specific areas of potential conflict or value loss that you would encounter in major projects. And I give you one example, which would be a legal concept called liquidated damages. Liquidated damages are what they sound like. It's a penalty for breaching some term of the contract. And it means that usually it's for delay, but it can also be for things like performance. It can be related to whether you've not met a criteria to provide documents that you're supposed to provide. There's some requirement of the contract that you've not met. And therefore, I say, Walter Romano's here. Oh, that's great.
I was just about to say this. We're getting some comments from your former colleagues who attended these courses live in our chat. So yes, I'll be displaying them as they pop up. And guys, if you're listening, if you're watching or listening us, please let us know if you have any questions to Mike. We'll gladly address them. Not only the questions that come from ChatGPT, which I also prepared, by the way, but also those that come from the audience. So thank you so much.
By the way, there are other managers listening here, other business people. Walter has his own activity in business. Actually, written a book, on leadership, and does terrific work in the area of like Walter's profile on LinkedIn, Walter Romano. He's terrific for those of you who come from the technical and business community. Anyway, as I was saying, this would be change orders, not changer orders on the chart. I teach legal writing. I think I'd get the typos right. But the liquidated damages are a quantified amount that you will pay if you breach a specific part of the contract. And it's very common to put this into lots of different contracts. Because sellers want to know, if I breach, what are the damages that I have to pay? It's predictable. And buyers want to know, if the seller breaches, I don't have to go out to court and quantify everything. I know exactly from the contract what I'm going to collect in the event of a breach. But in big contracts, liquidated damages can amount to hundreds of thousands, if not often millions and tens of millions of dollars. And one of the things I think that people who don't come from a, let's say, international legal background may not realize is that there are lots of arguments as to why liquidated damages may or may not be due. And it's something that you don't necessarily have to pay. If you're the party that's paying the party, you may very well have a good reason to negotiate the liquidated damages. And so we built a course around this very frequent issue that I have to say, this is to the credit of Nuovo Opinione and to the credit of GE Oil and Gas at the time. One of the biggest problems that the company had is that it was often late with its deliveries. The reason it was late is because it was so successful. The factory was full. They had a backlog, and they were often having to choose, which order am I going to prioritize? And sometimes there'd be events of force majeure. There, ships would get delayed, and there would be things that were beyond the company's control that would cause delays. So it was very topical, and so we had this course on liquidated damages. And the other types of courses would be change orders, where you modify or amend a contract. Usually contracts have a process spelled out for how they do that, but even if they don't, that's something that can be negotiated. You may want to negotiate additional time. You may want to negotiate additional money. You may want to negotiate both. The customer may want to negotiate, I want something changed. If you're building a house, you would say, look, I changed my mind. I want to have 3-meter windows instead of 2-meter windows. And the contractor may say, yeah, but we already, put the masons have left, the electricians are there, the plumbers are now working, we're about to start painting, and now you want to change. I'm gonna have to rip out and you say, well, look, I saw down at the local shop down here that 3-meter windows only cost, I don't know, $1,000. Why are you asking me $10,000 to put the windows in? And the contractor will have to explain, well, because I got to bring back the masons, bring back the electricians, et cetera. I mean, these are all things that I think are negotiated, and they're complex, and it's good to have the skill for when you negotiate that, and other things that are similar. So that was the level 2. And then our level 3 course, was master courses for very senior project managers, the people experiencing, and the ones that we wanted to bring back into their community and into their organizations. We had, like the folks I named earlier, people like, Professor Richard Schell from the Wharton School, and of course, Professor Mike Wheeler from Harvard, who were very generous in coming over both to Italy and other parts of the world, where we could get large groups of project managers together. Anyway, very long-winded way to say that's how I came to the world of negotiation.
But to summarize it, right, you went from a huge workload into inspiring many colleagues, some of whom are still with us and are very happy with the interactions that they've had with you. So another comment, you are an undisputed authority, and that's why you're here. That's why we're asking our questions. So as an undisputed authority in conflict resolution domain, Mike, I'm sure you've resolved so many disputes, right? What is the most memorable dispute that you've ever encountered, resolved, or maybe it wasn't resolved? Maybe it was left unresolved. But what is the one that you recall when you think about the most memorable experience from dispute resolution?
Yeah, I'll tell you the one that sticks in my mind is one that didn't resolve, and this was early in my career. And I just come to Nuovo Opinione, and I just started on this GE EDR, this early dispute resolution program, and I had this wonderful outside counsel, a professor here in Florence, Professor Vicuriti, who just passed away last year. And we had a dispute in the Italian courts with a company from southern Italy, from Bari, that had built cabins for a big project that the company was working on in Russia. And they had put in a claim for, I think, what in today's, what then at the time would have been, this is back in the age of lira, but in euros would have been about 5 million euros. So it was a big amount to them. It was a family-run company in Bari, a family-held business. And we, of course, are a large multinational, but I was trying to settle these disputes. And the interesting thing about this case is it was fully reserved on the company's books. In other words, we accepted that there was a probability that we might lose, or that it was more likely that we would lose, but not that we would necessarily lose, but the probability was estimated before I became involved. And what that means in in-house counsel terms is that anything that I could settle the case for that was less than the full amount was all upside for the company.
Right.
So that was a case that I prioritized to try to settle. And I remember Professor Vigoriti helping me organize a trip, and we made our trips to various different places with other disputants, and we met with the opposing counsel and I think the owner of one of the main owners of the company that was suing us. And we said, we would like to sit down. And I said, there are some elements of your claim that we don't really understand. There were things that were legitimate. There were some procedural defects in their case, and there were some substantive defenses that we had that we were in the process of building, and actually looked pretty good to me. I think that we could maybe turn this around, and we might be able to. This case, this is the litigation side of me, right? I think that there's if we don't settle this case, maybe we're not going to lose it. We could do. There's more here that we could do. It was a very difficult conversation at the law firm. I remember this in Bari in southern Italy. And the lawyer for the other side was almost, I don't want to say skeptical. He was skeptical about, and I proposed, I said, what about if we had a mediation where we can all sit down together? And he said, I don't know what mediation is. And I said, mediation is where we would be guided by a third party who would help us kind of understand these issues and facilitate potentially a settlement. And he looked at me and basically threw us out of his office, saying that we already have a neutral third party. It's called the judge. And we're happy to wait for the judge to decide this case. This was in 1999. I think the case was filed in 1997. I left the company that then became Baker Hughes in 2021, March of 2021. I think that case finally got resolved through the courts maybe 3 or 4 years before I left. So maybe 2015, 2016. I say this because by the time I was prepared to pay a sizable amount of that claim. I mean, I just needed the elements to help me understand and make an offer, right? So when they eventually, I think they eventually did win the case, but I think they won a relatively small amount. It was much smaller than the amount they were claiming. There was nobody there to collect it. The company had gone into liquidation. They got into liquidation years and years before. It was the liquidators. It was being held up. They only had one asset, which was this claim against Nuovo Pignone. They kept the company standing. The lawyer had passed away long before, the one who sent and the owners of the company had all passed away. So I have no idea who it was who ultimately collected. It was a few €100,000, I think, that they ultimately were able to collect. And I look at that as a lose-lose sort of situation, and I think that kind of shaped a lot of my thinking. And I probably needed better skills. I kind of looked at that as a failure overall. I didn't communicate well. I don't know how I presented it. So that was one that was really memorable. It certainly burned its way. I can give you lots of them. I had great experiences in mediation, wonderful, but I think that was one that really shaped me early on.
So, Mike, if we look at this one and many other disputes that you've managed to resolve while acting as a litigation lawyer, corporate litigation lawyer, what are the most common issues that arise that individuals and companies have in this context? So here it seems to me that in the last one it was more or less ego, right? Inability to say, hey, let's look at it from a different perspective. Let's involve someone from outside. What are the other substantive or maybe relational or maybe outside issues, aspects from outside of the negotiation context that play an important role in that case?
In this case, or I'm sorry,
in general.
The relationship issues often come up but that's part of. I think you factor those in, and I think any smart business person will, of course, be mindful if there is a relationship issue, if there are cultural issues that might arise. One of the advantages of working in an international company is you have access to people who are familiar with the cultures around the world, and the people who they're dealing with on the other side, and who are often from those cultures, so they can help guide you on that. I think if we look at, and we should talk, I hope we can talk about negotiating, otherwise it becomes bait and switch. So we'll talk about negotiating international commercial contracts. I appreciate we spent some time on my background. But I think that one of the things that often goes awry and leads from, let's say, a good commercial relationship into a dispute is that one or both parties, I think something happens which was not expected at the time that they signed the contract, and then one or both of the parties does not have a clear objective. They don't have a clear idea of what it is that they would accept. And I see this I think this is an important thing that is often overlooked. And that's why I think mediation is often a powerful tool, because it can help, one or both sides understand what they should reasonably want to have from the relationship or from the thing that they're dealing with.
We got another question from our audience. How do you manage intractable parties from your experience, Mike? What do you think?
Well, intractable parties, first of all, are they intractable? This is one, by the way, and I recommend the book that William Ury has written, Getting Past No, which it's a very easy book to read. You can read it in about an hour and a half, and he lays out 6 strategies for dealing with difficult people. But one is, are they really, it could be issues of communication. You have to look every single case on its own merits and try to figure out why are they being intractable. As some of these other podcasts, by the way, in this series have pointed out, sometimes negotiation is not the solution. Sometimes it's not a panacea, and sometimes you can't get the solution. But I think one of the things when we used to talk about in the courses was the difference between positive and negative negotiation zones, and make sure that everybody understood, am I in a positive negotiation zone? Is it, to this question, is it possible for me to reach an agreed outcome here? Because if it's not possible, I'm just wasting my time.
Right.
And if I on this thing, is there something else where it might be positive we can reach an agreement on? For example, maybe we're not going to reach an agreement on the particular dispute we're dealing with, but maybe we can reach an agreement. I don't know. So we're talking about delivering a thing, but maybe we can negotiate over the servicing of the thing down the road, and that can help us reach agreement later on, or maybe if we do or we don't. But it may be a way to help you get beyond. Look for those positive zones of negotiation where you can reach agreement.
Right, and let's have a look at the book that you wrote on negotiating international commercial contracts a little bit closer. So, 2 questions. How did it all start in terms of what brought you to an idea of writing a book about it, and what is the book all about?
Okay, so the again, not to trumpet so much your prior podcast, but I think some of your previous guests have talked about the importance of expertise, and it is there's no substitute for knowing what your domain expert, being a domain expert. So if you are somebody who works in real estate, you should understand, obviously, real estate. If you work in my former industry dealing, liquid natural gas installations, you should know a lot about liquid natural gas installations and the machinery and the components that make part of that. If you're working in banking and finance, et cetera. Most people have this domain expertise in a particular area. And this is true also of lawyers. Lawyers, of course, are domain experts in the law. But we learn our law and our procedures and our practices of our homes where we are trained. When we engage in international commercial negotiations, we are very often being presented with either a request or an opportunity to go outside of our area of training and expertise. And that is where I've seen time and again, people often make suboptimal choices because they prefer to go with what is familiar to them as opposed to going with what would be best for them or the party that they represent. And so this was really the inspiration behind this book it's an exercise book. I'd say you could call it a coloring book. I thought we could call it a coloring book, but people would find that maybe a little bit, I wanted to really illustrate. This is just a practice. This is just sit down, get your hands dirty, and practice dealing with the types of problems that you would face when you take your expertise out of your domestic area and you engage in an international contract. And my co-author is Gustavo Moser, who at the time was a senior case manager at the London Court of International Arbitration, and has certainly seen from another side, another point of view, many commercial contracts that did not work out for one way or the other. Anyway, a lot of disputes that arise because of imperfect negotiations, because the parties perhaps don't completely understand the impact of working internationally, and often they will accept a compromise position, which is neither here nor there. And so the idea was, well, if you give people exercises, they can practice this when they find themselves in a real situation, then they can they will be more confident.
That's a perfect moment to blend in Alexander's comment, who says that negotiation and handling these cases is something that we can learn. It's a skill, right? And which indeed calls for an approach that you chose in your book, meaning the more we practice, the more automated our responses to certain real life situations become. Right, we make connections between premise, conclusion, right, or problem, solution, right. So and that's pretty much goes in that direction, right? It's something that we can learn.
Absolutely, and even to Alexander's point, I think that there are very particular skills that one would benefit from having, which is that in the common law jurisdiction, we are accustomed to, in the tradition, to what's called attorney privilege, where any communications or settlement discussions are treated as confidential. That's not a given in many other parts of the world. And so I think Alexander's absolutely right to highlight the point that you have an ongoing litigation. You certainly want to make sure that you're talking, to somebody who has the right skills in the exchange of information, usually a lawyer who would be in the relevant jurisdiction, who could advise on that, or what you do is you and I hope that Alexander would agree, you just treat any communications you have with anyone as non-confidential. So make sure anything you send, you're comfortable that, well, if this gets out, then I'm okay with this getting out.
So, Mike, you've been active in the field of dispute resolution or commercial contract, international negotiating international contracts, or resolving disputes resulting out of those contracts. And I was wondering, if you look back at the decades of your experience at the negotiating table in that particular context, what has changed over those years and what remained the same?
So what's changed over the years? Look, things have changed. Well, lots have changed. One, I think, that is a macro change is that you see the acceptance of mediation all over the world today. When I began in 1999, outside of a few select jurisdictions, the UK, the United States, maybe a few others, Australia, mediation was virtually unknown. Maybe Norway, I think, was ahead. Today, it's practiced everywhere for different reasons. In the United States, mediation is a way for parties to negotiate their way out of a dispute and avoid the high uncertainties, but also the high costs of litigation.
Yes.
The same in the UK. In Italy and other countries, my colleague Chiara Tondini has actually written a very fascinating article about how Italy and Georgia, two different countries, have introduced mediation laws and introduced mediation in different ways, with a different purpose, which is litigation is not as expensive in either Italy or Georgia. It's being introduced, or has been introduced, with the idea of reducing court backlogs. And this is true of many civil law jurisdictions, which gives rise to different dynamics, but coming at the same, different problems with a similar solution, which is mediation. So that, I think, mediation requires negotiation skills. Mediation is a form of negotiation. I think that other forms of dispute resolution, I think arbitration is always, very accepted, increasingly accepted. I think arbitration has changed dramatically. I think today it is much more focused on the parties, the users, less on the arbitrators themselves. It's become, more. I think it's perceived more now as a service, which was what it was intended to be. I think that's my perception. There's been this evolution in that way, and I think that I'll tell you one thing that has not changed, and this I wrote a short article about this. It was published in mediate.com, which I don't think that negotiation has evolved in its accessibility to let's say to the uninitiated. I think that people still today who want to learn more about negotiation for their situation have the same sorts of texts that they go to, whether it's Getting to Yes. There are lots of good books. I'm not criticizing these. I'm just saying that there's nothing that has made it easy for parties to go out and find what is the right type of negotiation training for me and what would work for my situations that I face. It's more it's kind of, this is one size fits all for this is an approach. This is what you apply it to everything. And I think that's something that I would hope will change, So anyway.
Michael, we know that probably on all our walls on LinkedIn and other social media and the news in the last at least month or maybe month and a half, maybe 2 months, have been full of different messages on ChatGPT. And I also asked ChatGPT to come up with a smart question to Michael Mcilwrath. And here's what ChatGPT responded. It told me to ask you about what is the most effective approach to negotiating international commercial contracts and why. I was, first of all, when I read this question, I thought, wow, right? It profiled you in the almost correct domain, not quite, but very close. So Michael, you're welcome to comment on ChatGPT technology or answer this question, whichever you prefer.
Well, okay. So I think, let me just speak now to ChatGPT. ChatGPT, you're a bit lazy. I think that you looked at perhaps one of the most recent things that I've done, which is an exercise book on negotiating international commercial contracts. I think if you really looked into me, you'd see I'm probably more known for dispute resolution. But hey, I give you a passing grade. You got part of it, so okay. The most important thing, I think, is I don't view negotiation as a game. I don't think that I think it's a way of communicating, of structuring things, of providing a framework. I think the most important thing in any negotiation and preparing for international commercial negotiations is expertise. The preparation, you'll be seeing the preparation that you put in, but the expertise that you bring to a negotiation and the preparation that you put into it. There's some people here who will remember this, or I can see who are listeners here, that I was very adamant that I would never attend a negotiation or a mediation with one of our teams unless we spent time in advance to come up with what I call the 3 numbers. The 3 numbers are, what's our goal? And again, the goal can include relationship issues. It can include lots of other things, not just a financial number, but what's your goal or your goals? What is it what do we want to achieve? And then, so if we knew our goal, then we would be able to formulate the second number, which is what would be our opening number or our counter offer. We would discuss reasons, the advantages of being the first to make an offer, or being able to be confident when we make a counter offer, because we knew the reasons why we were putting that number forward. And then the third number was the fallback, or people in the negotiation will call the BATNA, the best alternative to a negotiated agreement. Some people might call it a bottom line, but I would try to remind people that, we are, as a company, we don't negotiate to our bottom line. We negotiate with our goal in mind, and we want to get our objective, but we also don't want to be stupid. And if there's a number that is, would be better, to accept and not accept, let's not be stupid. Let's think about what that number is. Getting those three numbers in a company typically would take a day. I mean, for any dispute of any size, whether it's $500,000, $1 million, but when you start getting into real money, and certainly much larger numbers, the reason it would take a day or at least half a day, even for matters that people knew very well, was because you had to think through the various options. How's this likely to pan out? What's a range of potential outcomes? What are the costs going to be? What's the impact on potential relationships or customer reputation? You have to get other people on board with this. Once you decide that, well, we might accept an offer that's less than 100%, well, you have to make sure that you're authorized. You may have to convince other stakeholders within the organization and make sure that you're authorized to do that. So those three numbers are, I think, the most important that you have to build any strategy. And I don't think you should go to any negotiation, unless you're able to articulate all three of them to yourself. Now, I hope that people have the flexibility to learn, to adapt, and to change them. But you should be pretty confident that, when you go to a negotiation, I know what my objective is. I know what my opening offer, counter offer would be, and I know what sort of fallback position, or bottom line I may have if I can't get to my optimal number. And I'm going to try not to be dragged to my bottom line, but I want to know what it is.
Yes, that's absolutely correct.
That would be my advice in every negotiation.
In every negotiation.
Yeah, but to get those, you need the expertise, right? You need to make sure you have people that you are informed, or you're bringing people who are informed. And so we go to negotiating international commercial contracts. You bring you're not coming to an international negotiation without having negotiated a contract before, right? You have that expertise. You should feel, bring your confidence with you, because you're the domain expert in that type of contract, and that's a good thing.
Mm-hmm. So let's now fantasize a little bit, right? Let's move away from the retrospective, right, of your rich and successful career, and try to paint the visions of the future. Okay? So, what do you think about the role of technology in the future at the negotiating table, be it negotiating commercial contracts or resolving disputes? Things like ChatGPT, artificial intelligence, and beyond. Do you think it has a legitimate place at the table, or besides the table, right? Or do you think it's a people's business at the end of the day?
No, you and I are aligned on. We had this conversation before. I mean, it's like you and I both, I think, see the same thing. It's a tool like any other tool, and it will be used, and we should be embracing it now and facing into it. I teach a legal writing course, which has a negotiation component as a part of it. I plan to use. I'm gonna incorporate it into my class next year. I'm going to require. Not only am I going to not prohibit students from using ChatGPT. I'm going to require them to use ChatGPT as in at least some of their assignments, because I think it's a tool. Richard Susskind, is an inspiration in the area of technology and dispute resolution, and I highly recommend his books to anyone who's interested. He's a genuine futurist when it comes to. He's the technology advisor to the Chief Justice of England and Wales. Has written a number of books on the future of the law, the future of the courts, online justice. He is fond of pointing out, and that is the way that we will be resolving disputes, which I would say is probably also true of negotiating contracts. The way that we will be doing it in 10 years will be based on technology that has not yet been invented, and we just need to get used to that. Those of us who can adapt and incorporate it into what we do will have one leg up. It's funny. I have a friend, one of my former team members, Chris Campbell, who has a podcast called Tales of the Tribunal. It's about international arbitration. And I mentioned this because I was talking to him the other day, and he uses ChatGPT to help him do his weekly updates of international arbitration law. He says it used to take him 4 hours to prepare the script that he reads. He says he now has ChatGPT do it, and he has it reduce it to bullet points, and he goes through and cleans it up. He says it reduced his time to a half an hour. So, and he's as first to say it's not perfect. He says, but I'm the person responsible if I clean it up. So I think we're bound to start adopting it sooner or later. Yeah.
Yes. So next week I'm speaking with next week Michael. Next week I'm speaking with Moshe Cohen about his new book. It's called Collywobbles. I mean, not so new. It was published 2 years ago, about stress associated with negotiation and how to overcome it. And I'll be more daring with ChatGPT. I'll ask ChatGPT to prepare all my questions and I'll just edit them. No, just kidding. Yes, but yes, technology is definitely here to stay. Last question, Michael. Thank you so much for sharing your expertise. My last question is always the same. I force my guests to share the most share their thoughts on great negotiators, mediators that they have encountered, found out about, read about, be it contemporary or historical. Who comes to your mind, Michael? Anyone in particular?
So let me say this. I've as being an in-house lawyer responsible for the things that I managed, I've had the opportunity to see some truly great negotiators. I mean, people who had just a tremendous depth of expertise and experience, and they were able to put that into action. And I've also been able to see mediators who are, and I think some of the world's finest mediators, who are people who see some great negotiators. And a mediator observes the negotiators at the table. And what I think that I would like to pass on to your listeners and viewers is what I've come to realize are really the two types that exist. I think this may be true of negotiators as well as mediators. By the way, there are all these jokes about there are two types of people, like the one about there are two types of people. The first type is the ones who can extrapolate from incomplete data. The joke ends there. But I do think that there are two types of mediators, and I believe negotiators. And I think the one type are those who are a one size fits all. They bring their approach to every situation in which they find themselves, whether it's a contract negotiation or it's a dispute they're trying to resolve, or a case that they're trying to mediate. The other are the ones that, to use the English word, are the bespoke mediators or negotiators, the ones who I have seen who really invest the time to figure out what are the things here that matter, what are the points and the people and the strategies to get to good outcomes here. I think there are advantages to both approaches. Taking mediation as an example, if you do lots of mediations and the lawyers want to say, I'm recommending Remy as a mediator because he does all his mediations a certain way. He gives the parties a form to fill out. You fill this out. He asks them to exchange documents, 10 days before the mediation. And he has all this laid out, and that's exactly how he's going to do it. There are a lot of lawyers who like that. But I've found that for particularly difficult, complex cases, that the bespoke, or Americans we say customized, the mediators who do things that to fit that particular situation are those who can get results even from what we would consider impossible situations. And I've seen impossible cases get resolved where you've had a mediator or negotiators who dove into it. And we had the question about the intractable party. Well, they're intractable disputes. They're intractable until someone comes along and figures out how to make them not intractable. And it's harder to get there in when you're doing the one size fits all, because you just don't see certain things, right? You just miss stuff. And so the really hard cases, I think, are just maybe think outside of the way that you, that's the kind of the theme of the book, is like, how do you do things outside your area of what makes you comfortable, and try to look at everything that might get you there. I'd say it's true of negotiators and for mediators.
Thank you so much, Michael, for sharing your wisdom, sharing your experience. For those of you guys out there who would like to find out more, you will find much more information about Michael and his approach on his website. Go to mdisputes.com, if I remember correctly. mdisputes.
Yeah, by the way, mdisputes.com. And could we close? And I hate to ask this. Can I do one problem from the book just for those people who are patient enough right along?
Please do. Yes.
I would like to just give an example of getting people outside of their comfort zones. And here's one, just a quick example. So the slides, I'll go to, here we are. Is it up?
Not yet, but which one is it? Is it this one?
No. Here we go. So here's a situation we have where very simple international contract. And we're going to talk about getting what is negotiating to get something that feels comfortable to you versus negotiating to get something that is maybe more optimal for you or the party that you represent. And in this case, we've got a international sales contract. The seller and her lawyer are from New York. The buyer and his lawyer are from Singapore. So the goods are coming from New York. They're going to Singapore. And we have just a multiple choice here. So which of the following is the New York lawyer most likely to choose, and which is better to protect her client's rights to be paid for the goods? Like, mind you, this is a sale of goods. So probably the only important thing for the seller here is to make sure they get paid, right? So yes. Buyers from New York. And so the options that we have here are A, silence in the contract on the form for resolving disputes. B, New York law and courts of New York to decide disputes. C is English law and arbitration in London in the event of a dispute. And D is Singapore law and Singapore courts to decide any disputes. So if we ask this from the point of view of the New York lawyer, we would say, which one do you think that she would be most likely to choose?
That's a question to me.
Yeah, I'm going to just jump in. It's like, it's a New York lawyer here. So we could probably guess that she would most likely choose New York law in the courts of New York.
Yes.
Yeah. Because
yes.
So that's the way most international contracts are wind up, I think, being negotiated, right? With the lawyer imposing one just being stronger. I'm the buyer or I'm the seller. I have more leverage here, so I'm going to get my law in my courts. But let's think of, we just said, what is the most important thing? It's getting paid, right? So which might be better to protect her client's right to be paid? The seller's in Singapore, right? If you're going to collect from them, you have to you can win an arbitration, but if they don't pay it, the arbitration award, option C, you can go to English law and arbitration in London. And of course, an award in London is enforceable in Singapore. But if they don't pay the arbitration award, you still have to sue them in Singapore. So Singapore courts have good courts, right? So this is a case where maybe choosing the buyer's law in the courts would be the better option. And that's a hard thing for lawyers or anybody to maybe wrap their head around, is that sometimes, the best solution is the thing that's the opposite of what I'm most familiar with. But I'd leave you with that. Just wanted to kind of get people thinking about how to, perhaps frame, their international negotiations as going beyond what is comfortable to them.
This and many other exercises you guys can access. You guys can gain access to in Michael's book, Negotiating International Commercial Contracts. And yes, further information on how on Michael's approach and his colleagues' approach to resolving international disputes, you guys will find on mdisputes.com. Chiara, thank you so much for your help. Thank you so much for being with us. And Michael, obviously also to you. Thank you so much for sharing your knowledge, your experience. I greatly enjoyed it. I love your sense of humor. It was a very healthy dose. I thought, I was slowly doubting that lawyers can be as charming and funny as you can. So thank you for restoring my faith in lawyers. So thank you so much, Michael. Thank you to our listeners and viewers. And until next time on the podcast on negotiation. Hey, and there is a happy guy next to you.
Booker,
so
that's Booker.
Take care.
That's my dog. All right. Bye-bye. Thank you.
You guys take care. Thank you. Bye-bye.